welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law. And well, hey, anything else we want to talk about. Now today, it's going to be directly in the area of estate planning and elder law. This is a solo podcast today, so it's just me. So we're going to have a little bit of fun. What I thought we would talk about today is things that have been coming up a lot recently. And generally, when things start coming up in the conference room or in the workshop room, it usually means that a lot of people are thinking it. There's something going on that people are hearing it somewhere else. So I definitely wanted to make sure that I spent some time talking about some things that we see popping up now, maybe more than the previous, or at least it's coming to our attention more. Maybe I'll say it that way. Just a reminder, as always, please do not take what you hear from this show or any other show to constitute legal advice. If you're looking for legal advice, please call an attorney licensed in the state that you live in, that you reside in, who practices in the area that you are looking for advice in. Meet with them, let them understand the facts and the situations, and then and only then should you take it as constituting legal advice and what you should do in your particular situation. This show and every other radio show is for informational, educational, and entertainment purposes only. At Bellomo Associates, we educate so that what happened to the Bellomo family does not happen to yours. We offer weekly workshops that are absolutely free in the areas of estate planning, pre-planning, Medicaid crisis planning, long-term care planning, life care planning, special needs planning, and administration, both probate and trust administration after the passing of a loved one. So if you're looking for education in any of those areas, please give us a call at Bellomo Associates, 717-845-5390. Once again, that's 717-845-5390. Or check us out on the web at www.bellomoassociates.com. Bellomo, B as in boy, E-L-L-O-M-O. That's Bell and then O-M-O, Bellomo. Excellent. All right, so first thing that I have noticed lately is on our Facebook posts and other posts where we talk about free education, we have been getting tons of comments back saying, yeah, sure, nothing is free. What's the hook? If you're reading them, you'll notice that I'm responding to all of them saying no hook whatsoever. We honestly and truthfully offer education for free, right? The workshops are free, absolutely free. You can't even hire us in the workshop, the first workshop. We want to make sure that you are educated. Once we educate, we tell you the prices, we tell you exactly what's going to happen, the pros, the cons. Sure, we would love for you to hire us. We would love to work with you. We would love to be side by side with you through this process and through the journey. But only after you've been educated, you know the cost up front, you know the pros, the cons, the goods, the bads, the uglies, and we will discuss all of that. And then, yes, after the education and after we're able to make sure that you're comfortable and understanding the process and the costs, then you can choose to hire us. So yeah, I would love to work with you. I guess the hook is I want you to like me. I want you to trust us. I want you to trust the firm. I want you to want to work with the firm. So I guess the hook is our goal is to have you hire us at the end of the day. But certainly the education part is absolutely free. Unequivocally, there is no question about that, and there is no hook on that. One thing that we have been seeing a lot in the conference room lately is families who do not have children. And they're wanting to know, what can we do? What are the options? What does that look like? So essentially, if there are no children, we always tell people what you're looking at is fiduciaries, right? We talk about, all right, who are you going to name as a financial power? Who are you going to name as a medical power of attorney? Who are you going to name as an executor in your will? Who are you going to name as a backup trustee if you have a trust? Now, in a lot of cases, those tend to be family members. Who are we going to leave the money to when we pass away? Again, often tends to be family members, tends to be children. But if we don't have children, that's okay, right? Now we take each role individually and we look at each role and what the role does and decides who in our life is the best person to sit in that role. So if you're married, maybe it's the spouse. And then after the spouse, we look to other family members. We look to other people that are close to you in your life. And we see, is there somebody who could act as a financial power, as a medical power, as an executor, maybe as a backup trustee? Who do we want to leave the assets to? Maybe you have a charity that's close to you. Maybe you have a family member that's helped you out. So every situation is unique. There is certainly not a one-size-fits-all answer to the question that we've been getting. But I wanted today to just talk a little bit about the fact that I think we should look at each one of those independently and individually, right? So somebody who doesn't have children might want to leave the assets to a charity or to another family member, but maybe they don't want the family member to also then act as the power of attorney, as the medical power, as the executor. They don't want them to sit in a fiduciary role. They're a family member that they want the money to go to, or they want it to go to that charity, but in either case, they're looking then who can act beforehand. Maybe it isn't that person. Certainly the charity won't act in those capacities, so now we're looking for another avenue. Again, I think you look to other family members, siblings, cousins, parents, nieces, nephews. But if at the end of the day, none of those possess the skills, possess the traits, possess the characteristics that we're looking for in a fiduciary, then I think that you look to a professional. There are definitely professionals who will act in the areas of financial powers, medical powers, executors. There is no question that there are professionals who will act in those areas. And I made a decision today. I am not going to name the people who currently are acting in those capacities, because what I am finding is that a lot of them end up getting so busy that they can't continue to do it. They can't continue to take on new clients. They can continue to do it, but they can't continue to take on new clients in that capacity. So that is where I am noticing that we're having an issue currently, because if I name someone here today and I say, yeah, you should be calling this person or you should be calling that person, the truth is they may not be able to take new clients. So we at our office absolutely have a list of people who can act in that capacity at all times. And it might not be the same person that we were using or naming 6 months ago, but that doesn't change anything for the people who are using those people already. It might just change that those people aren't taking on new clients. So rather than name those people today, I have made a decision that instead we are simply going to just say that yes, we always have options for people to act in fiduciary capacities. I am constantly meeting people who are in that arena. I'm even suggesting to people to open up companies in those arenas if I see that they possess the skill sets that are necessary. So we generally will always have the ability to give you that referral or give you that name. That generally is never an issue. But currently on this podcast, I just decided that it didn't make sense to name them currently, because I'm just hopeful that they can continue to take new business, continue to grow their businesses, and grow with the capacity, grow with everything that's coming in. And that'd be awesome. So what I would say to somebody who doesn't have a family member is, or a child, it's okay, right? You still have close family members. You might have nieces, nephews. You might have other people in those in your world that are important to you. Maybe they're not blood. Maybe they're just friends. But if not, then I would definitely look to charities. Look to organizations that are important to you and your family, as far as making sure that you can give those assets that you have worked so hard for onto those individuals. We can definitely cover the fiduciary part with professionals, and then the assets where they want to go is really a personal choice to you. Just a quick reminder, as far as the taxation differences go, If you're providing to a charity, to a 501c3, there is no inheritance tax. If you're giving to a lineal descendant, child, grandchild, parent, grandparent, it's 4.5%. So if maybe you don't have a child, but you have a grandchild, it's still the 4.5. If you go to siblings, that's 12%. And then if you go to nieces, nephews, and anyone else in the world, it's 15%. So there are some inheritance tax consequences as far as leaving to individuals that are a little further removed, but you've already passed at that point. Taxes are basically a necessary evil. And if you've listened to the other podcast, you understand why dying with assets in your name alone is very important, why it's actually a good thing, or not necessarily in your name alone, but that you control at the time of your death. And that's where we talk about the trusts, because then whoever receives them gets that step up in basis at the time of your death. So there are advantages to that. And, I just wanted to take a few minutes today talking about, if you're sitting there and you don't have children, that doesn't mean that you shouldn't do estate planning. In fact, it probably means that it's even more important for you, because you want to make sure that it goes to the right people, that you name the right people to act in those fiduciary capacities, because you don't have a child to just fall back on. I think it becomes extremely important for you, and I think where the money and where the assets end up also is extremely important, to make sure that it honors your wishes and what it is that you want to carry out your legacy after you're gone. So start taking a look at professionals if you don't have a family member to act in the fiduciary roles, and also start looking around to the charities that are important to you. Who do you want to support? And then when you're ready to have those discussions, reach out to the law firm, and we'll be able to guide you specifically on what that will look like for you individually. All right. So another thing that we have been seeing coming up more recently for sure than ever before is a lot of estate planning workshops are being held. So you are seeing all kinds of people doing estate planning workshops currently. We are seeing financial advisors hosting estate planning workshops. We are seeing insurance agents hosting estate planning workshops. I asked one of our marketing people why that's coming up all of a sudden and why we haven't really seen that in the past. And her response was, I have talked to some large national companies who do mailers, and what the word on the street is that estate planning is a very hot topic. Estate planning is something that gets people to show up in rooms to listen to workshops or listen to seminars. So the advice from these companies that are working with financial advisors, they're working with insurance agents, is just do a seminar on estate planning and you will get people in the room. Now, for years and years and years, Bellomo Associates has teamed up with financial professionals, with insurance agents, and we have joined them in workshops. They would teach about the financial professional side, they would teach about the insurance side, and we at Bellomo Associates would talk about the estate planning side and the elder law side. And it has worked phenomenally. It's worked incredibly well. I mean, we've been doing workshops for over 15 years on a very regular basis. I mean, we're talking weekly. We're doing over 10 a month currently at Bellomo Associates. But what I think is happening is others are seeing the ability to educate, and they're trying to pull those people to get them in the room. Now, I've talked to a few of them who are doing it, and they have zero intentions or hopes at really becoming the estate planning person in your world. They are literally educating on something that they don't know anything about simply to get you in the room. And maybe they will even do your wills. Maybe they will even do your powers of attorney. We have talked to some of them, and they literally are financial professionals writing wills and powers of attorney. I saw one company that's doing it that has an attorney in Nevada. And the attorney in Nevada never, ever meets with the client. The attorney in Nevada is literally just the figurehead to say that we work with an attorney. But that's not really working with a licensed attorney in the state of Pennsylvania. You're never going to work with that individual on a one-on-one basis. Another company that we spoke to literally verbalized, well, yeah, we have forms and we do them. We do them in-house. And we asked, well, who's the attorney, in your firm? We don't have an attorney. That is the unauthorized practice of law. That is not allowed in the state of Pennsylvania. Estate planning and elder law is one of the most important things that you are ever going to do for your family. It will protect them. It will make sure that it reduces the taxes. It will make sure that the money goes on to your family members protected for them and only them. But I am telling you, working with somebody who doesn't do it for a living, who is not a certified elder law attorney, who is not in this arena on a daily basis, is a very risky proposition. So I did ask one of my friends, why would they do that? That doesn't even make sense. Why don't they just bring an attorney in or someone in? And the response was, because they are really trying to get the assets under management, or they're trying to get the insurance sales or the annuity sales. That's where their money is. And because estate planning has become such a hot topic, they can fill the room with 100 plus people. And if they fill the room with 100 plus people, now it's a law of averages, right? Now you might get 35, 40 people to move forward. They're not worried about the estate plan. They don't care about that. That is just a one-off. That's just something to get them in the door to go ahead and sell them these other products. I genuinely believe that the person who you work with on estate planning and elder law should not be licensed to do any of those financial products, financial advising, insurance, annuities. I think they are very much different. It is absolutely a conflict in my opinion. And certainly when they're not even attorneys, you shouldn't be dealing with them. You should not be sitting in a room making a final decision about this, about your life, about your planning, about what you're doing, when you have not spoken to, heard from, discussed with a licensed attorney in the state of Pennsylvania, with a firm that has a certified elder law attorney in it who is guiding that type of planning. It is very scary to me to realize now in our areas that most of the estate planning presentations that are being taught are not being taught by lawyers. They're being taught by financial professionals and insurance agents, and they don't even have somebody licensed on their team to be an estate planning attorney or a licensed attorney to sign off on the documents. And to the extent that some of them do, they're working with an attorney in Nevada or Delaware. That scares the crap out of me, and it really concerns me because I don't think that people locally are understanding what's occurring and the risk that is imposed with that, and how it is just so crazy to me. And it ties into another sort of situation that we have noticed recently that really does kind of bring this all together. I was talking to a financial planner recently who was working with a mutual client, and he said to me, he goes, Jeff, I'm not really a fan of what you're doing. I'm not really a fan of what you're recommending. For years, I have been telling people to avoid probate, just beneficiary designate everything to whoever they want to, avoid the lawyers, avoid the cost, avoid probate, avoid everything. And now what I'm hearing is in these workshops, you're telling people they should be doing a living trust, a revocable living trust to avoid probate, and to pay you to draft all of that, when it just doesn't make sense to me when they can just do it with beneficiary designations. Now, after a 40-minute conversation, he was completely on board, completely changed his tune. But it just kind of hit me when I realized everything that's going on currently around us with people doing these presentations who are not really understanding asset protection or elder law or understanding how to really protect the family. So let's talk a little bit about, we have something called probate and taxation, or probate and inheritance tax. Please do not confuse the two concepts. Probate is merely the way by which we get the asset to someone if the person who passed away owns the asset in their name alone at the time of their death. Whether they have a will or not, that goes through probate if the asset was in their name alone at the time of their death. If they have a will, an executor is named. If they don't have a will, it goes through intestate succession. An administrator or administratrix is appointed, but that is still the probate process. That is how we carry out your wishes for assets that are in your name alone and get them where you want to go. Now, if you beneficiary designate an asset to a family member or to somebody, the asset does not go through probate because it simply transfers to them at your death. So it does not go through probate, but it is subject to inheritance tax, right? Still at the same rates, 0 to a spouse, 4.5% to lineal descendants, 12% to siblings, 15% to anyone else in the world, including those lovely nieces and nephews. So the taxation piece doesn't change. But here's the problem. If I'm named as a beneficiary on accounts and all those types of things, in my brain, that money comes to me pretty quickly upon the passing of a loved one, which was the advisor's point. I can get that money to them almost instantly. They don't have to pay lawyers. They didn't have to do all this fancy planning up front. And I said, okay. So if I receive the money as the child, as the family member, what does that tell me? It tells me that that's my money, right? It tells me that I'm good to go. About 6 to 8 months after that money has already transferred, after the person has already passed away, and the child has already received the money, they get a love letter. What's the love letter? It's a love letter from the Department of Revenue saying, hey, don't forget about us. You owe inheritance tax on the money that you received 8 months ago. And it's at the rate of 15%. So please remit payment immediately. Now, they take the position almost always that it's 15%. And their thought process is it's up to the child. It's up to the sibling to know that their rate is 4.5 or their rate is 12. And then it's on the person to change the rate, change the calculation, and pay the right tax. Well, we all know that that doesn't always happen, right? And not to mention that if you pay a prepayment on the inheritance tax, right, then 3 months of the date of death, there is a discount of 5%. Well, if you receive money directly outright and you don't get that love letter for 8 months, you didn't even know that you owed inheritance tax, let alone the fact that you could have taken advantage of a discount. Holy crap. But in either situation, it's 8 months later. Now the child realizes, I owe this money and I don't have it. I owe this money and I always tell people, you can mess around a lot, but you don't want to mess with the government when it comes to owing taxes or when it comes to owing that. So whether it be the Department of Revenue, whether it be the IRS, those are not people to mess around with when it comes to owing tax. So we don't want that to occur. We don't want that to happen to a family member. So there's one reason why I don't necessarily agree with just beneficiary designate everything. But also, let's remember, how does the money go outright? When you have a beneficiary, it goes outright, right? I name a beneficiary, it goes outright to my spouse, it goes outright to my child. I'm not going to go crazy in depth in this podcast because I've done it on many other podcasts talking about why I don't believe that outright distributions are ever a good idea. But I want my wife to enjoy the money that comes from the retirement accounts, the life insurance, the joint, the accounts that are in my name. I want her to enjoy it, to spend it, to do whatever she wants with it. But I don't want her new spouse to get those assets. I want them to go to my daughter, right? I worked very hard building the practice, and she did as well. And she can do whatever she wants with her money. But I want to make sure that my money ends up with my daughter. My wife can spend every penny of it. It's all hers. She can do what she wants. But when she passes away, I don't want that money to go to her new spouse. I want it to go to my daughter. So outright distributions do not allow us to do that. So with beneficiary designations, we can name the trust after death for the spouse. We can name the trust after death for the child, which will allow only the child to get the money and allow my daughter not to lose it if someone files for divorce. So she's not going to lose half of the fact that she went ahead and paid off her debt. She paid off the mortgage on their marital property. He files for divorce a month later. Bam, he takes half of the value of that property. No, I don't want that. I want to make sure that I'm beneficiary designating the money correctly. in a way that goes into a trust. So it might be okay to use a beneficiary designation to avoid probate, but I need the documents to have the trust in place for the spouse and for the kids. Not to mention, how do we make sure that the planning is done correctly up front so that the power of attorney provides for the ability to do asset protection planning if somebody ends up in a long-term care situation, so that the documents themselves provide for asset protection during life? So my point to the financial advisor was, look, I am not saying that everybody should just have a revocable trust. And I'm also not saying that you need to avoid probate by using a trust only. But I will tell you, there are a lot of financial institutions, a lot of banks that will not allow a beneficiary designation to go to a trust. They just flat out won't allow it. So the reason that we've been using a lot of revocable trusts is because the assets that we're not protecting in the asset protection trust, I want to make sure get out of probate, but that they ultimately get into the trust for the benefit of the spouse, the trust for the benefit of the child, whoever it is. I want to make sure that those assets go where I want them to go. If we use general practice attorneys, do-it-yourself kits, insurance agents who got a form, or financial advisors who got a form, and they're not actually licensed and practicing in the area of elder law, I guarantee you that those powers of attorney are not going to authorize the ability for your family to do what they need at the time. It's not going to provide for the asset protection planning. I cannot tell you how many families I had to look in the eye and apologize because I wasn't able to assist them when a loved one was in a long-term care facility because the power of attorney didn't authorize it. Those general practice attorneys, the do-it-yourself kits, the person who works with an attorney in Nevada, the person who is not even licensed, doesn't even pretend to be licensed to practice law, and they're just an advisor who got a form, those are not going to protect you. I do remember when I was in my first job working at a law firm out of Harrisburg, I had to do a research assignment on the phrase caveat emptor. And I remember vividly from, I think it was the year 2000, caveat emptor means buyer beware. So please beware of situations where you're being invited to hear about a topic that somebody doesn't specialize in it, someone doesn't practice in it, someone who doesn't do it all the time, especially if they're not even a licensed attorney, especially if they're not a certified elder law attorney. But always pay attention to that, right? You want to make sure that you're protecting your family in the right way. Yes, I agree we should avoid probate. But how about we do it in the right way that not only are we going to protect and get out of the probate process so that lawyers don't end up with all the money, but let's do it in a way that protects our family during life and after death. That's the key to all of this. Honestly, the only option is to go with a certified elder law attorney. And this isn't about us. This is about making sure that you're working with someone who has hundreds of hours in the area that you're looking in, was able to pass a test that at the time I took it had a 19% pass rate, and has worked enough years in the practice to be able to sit for the exam, pass the exam, and get through all the rigorous referrals and references that are needed. That's where I would start. Absolutely don't be going somewhere where someone's not even an attorney who doesn't do elder law as a first start. So that we have been seeing come up quite a bit lately, and I just wanted to take a few minutes to be able to discuss that with you. So what a fun podcast, man. This was great. I had so much fun on this podcast today. We talked about all kinds of fun things, right? We talked about families who don't have children and how do they name fiduciaries and how do they know where the assets are going to go or who to name. We talked about bewaring of financial planners or insurance agents who are doing estate planning seminars. And we also talked a little bit about how we want to do proper planning. And yes, avoiding probate is one piece of it, but that really isn't the major part of what we're trying to accomplish. And we can't accomplish what we need to with just using beneficiary designations. I hope you enjoyed the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law. And well, hey, anything else we want to talk about. Today, we were squarely in the estate planning and elder law arena. I had a ball. I hope you did as well. Again, we have weekly free educational workshops in all areas, such as pre-planning, crisis planning, life care planning, and administration after we lose a loved one. Thanks for joining us on the Red Wagon Estate Planning and Elder Law Show. Until next time, we'll see you real soon.